Hi, welcome to Legal Tech Diaries. As you know, my videos are split into two parts. First, we discuss the legal side of the topic, and then we shift into a legal tech side to see how it functions in modern legal practice. Today, we're going to explore the topic when and how the offer can be come to the end. So, but before going to the termination ways of the offer, let's shortly discuss about the phrase of subject to contract. When a parties use the phrase subject to contract, that means that they are still in negotiation process and all the documents exchanged are still not binding them. So this is no legally binding process. In this case, when they are in a negotiation, that means that even they accept most of the terms, they can still change the mind, they can walk away or renegotiate, and it wouldn't be a breach of a contract as they are still in the negotiation process. The contract would exist as a legally binding contract when it is a formal, and even if the parties have exchanged the expenses, and so to say the expenses has been incurred, they can still withdraw from the contract without any reason and in any time. So this is legally, they are not liable for that, and this is not a breach of the contract. This ensures that the parties cannot accidentally be forced to be legally binding very soon, so very soon, in a very soon stage. So now let's talk about termination ways. There is a revocation by the offerer, rejection by the offeree or counteroffer, lapse of the terms, failure of condition, and death of offerer or the offeree. So let's start with the revocation. Revocation by the offerer can be in any happen anytime before it has been accepted. So this revocation can and should be communicated with the offeree. Rejection by the offerer. The offerer who is receiving the offer can reject it, and this will end the offer. The counter offer what means that the new term has been suggested would end the original offer, and the new offer, this one, should be the counter offer would be the new offer. The lapse of the time. An offer should be accepted in a term, in a specific time, and if it's not set a time when it should be accepted, it should be in a reasonable time. So if it's not accepted in a reasonable time or the set time, that the acceptance that the offer would be expired. The death of one party or both of the parties, an offerer or the offeree, can also end the offer based also on the situations and the type of the offer. So the counter offer is something that brings new terms in the offer. So it means the terms, a new term has been suggested or the old ones are altered. And in this case, the old offer would be ended, the original, so to say, and this one would be the new offer, as it was in the case the as it was in some of the important cases. So, but there is also, we should note that an information just an information, mere information, could not be a counter offer, and it's just an small information the offer needs to accept, needs, and it has nothing to do with the acceptance. And the next one would be the revocation. That revocation can be, as already mentioned, done anytime before the acceptance, and even if had an or if it has had it has a time frame to accept, as it was in a paint and cave case. So if the offerer rejects outright reject the offer, then the offer ends, and it could not come back to the original offer if it not what not done again. But in a unilateral contract, the revocation is possible if the contract, if the offer, if it has not still been performed. But the performance also should be full, so it cannot be done the half performance. And if it's done half performance, then this is not performing of the specified act. As a next step, it's as that the offeree can reject, and which ends the offer. But it's possible that the offer says that it's not outright canceling, rejecting it, but saying I accept it if, and this is another type of acceptance. This is conditional acceptance, which means that the party would accept it if the conditions are if other conditions are met, some other conditions are met. And this is a new offer, and it would be like a counter offer, so it would have the terms to accept it, time to accept it, and it would be meant that it is that it is a counter offer. It's also possible that, like it was in the case of Victoria Hotel, it is also possible conditional precedent acceptance. That means that before it would be accepted, something should happen. It is established in the case financial versus Stimson, and in this case, the car, the offer was about a car, and the offer should be, and the car should not be damaged before the acceptance. But before the offer was accepted, the car was damaged, and there was after that no offer, because the offer was dependent on this condition of a good state of the car. So we have reached the legal tech part, and in modern platforms like Juro, it is possible already to integrate the logic of terms, the logic of the timing. And for example, the terminations could be in this platforms. And in this case, the logic would help to see the tag if something has been changed in the terms or a new term has been suggested, and this will be tagged as a counter offer, and it would stop the acceptance before it is acknowledged by the parties. Then regarding the consideration, conditional acceptance, it can alert, and also it should be mutual, alert the parties, and it should be a mutual it should be mutually requested to be proceeded. And the smart contracts. In the smart contracts, it is possible to integrate again the logic, if this, then that. And this logic would ensure that all the conditions are met before the acceptance, as it was in the case of Financial versus Stimson, and where the car was damaged. So that means if the condition is depending for the acceptance and this is not met, then it would prevent to proceed the legally binding contract. So that's all about the terminations. Thank you for watching and see you in the next video.